Okay, it is Monday, October the 28th, and welcome to week 5 of constitutional law. And as each of you know by now, my name is Richard Wright, and I told you some 5 weeks ago that this quarter was going to go really fast. And next week is the final lecture for this class. And I announced last week, and I'll reiterate again, that all assignments from week 1, 2, or 3, with the exception of discussion posts, which we can't accept late, will not be accepted after, well, actually, as of now, because week 4 has ended. We are in week 5. So I mentioned last week, so everyone had a chance, even if they were getting them in late. I will not accept weeks 1, 2, or 3 from this point unless I have previously made arrangements with you. I don't recall anyone in this class that I've made any arrangements with. If I have, and you end up wanting to submit it and you get a 0 because it's late, then you need to reach out to me by texting me or calling me, and we could discuss it at that time. So at this particular point, all late assignments from week 1, 2, or 3 should be in. I will deduct points from those, and especially week 1, because that's the beginning of the course. And so we're going to go ahead and get started today. We have a very interesting topic, one of my favorite topics under constitutional law. And we're going to go ahead and I'm going to share my screen with you. Okay. And I scroll down through all this information because you're familiar with this. And I go right down to the rubrics. So we're dealing with week 5. So your written assignment, which I'll elaborate on when I get into the module, based on the rubric, which I always recommend students make sure they use as a checklist to make sure that you've complied with all the requirements of the assignment. I've said that since day 1. So this week, its written assignment is voluntariness of a confession. And to get 80 points, you're going to get a total of actually 2 sections. You're going to explain what makes a confession involuntary. Not voluntary, but involuntary. Include reasons found through your research. And you know already that you supply credible resources. Excuse me. And when you use cases, make sure you use the full court case citation. I've given you examples of that in previous assignments, and you're familiar with that too from your briefs that you've done. And then the 25 points, find and summarize a case where a confession was held to be involuntary, given and explain the court's holding. Now, it says find and summarize. You can do that. You don't have to do a full case brief, but I personally, if it was me, I would do a case brief of a case that I found, because that way it's given pretty easy. Make sure you use proper case law citations for 20 points. If you don't, you're going to lose points. And then meet the page requirements, APA citations. Now, very important. I'm going to tell you what the page requirement is in a minute. Then we get down to your next written assignment, which is your course project, which is actually the interview. So for this, you are supposed to, and you're supposed to have prepared for this earlier in the quarter, interview a law professional about your Fourth Amendment area, the one that you chose during week 2. And you're going to use citations in the body and references at the end. You're going to outline what is covered and who the subject is as well when it comes to the Fourth Amendment area that you chose. And then you're going to satisfy the same requirements in all written assignments. And so that's it for week 5. You will recall, and we're going to get to, like I said, I'll give you details in a minute. You see here that your final lecture will take place next Monday. We're at the week 5, and your previous 4 lectures are here. So now let's go over and see specifically what the announcement has that I have provided for you. Here it is. So for the 5th week, we're going to deal with suspects' rights, and very valuable tool to those of us, such as myself, who were criminal defense lawyers for many, many, many years. And we're going to talk about the specifics in that. So you're supposed to read, have gotten chapters 10 and 11 of your text, and I provided you the corresponding information that will help you find details that would help you too in your research. And also I provided the accompanying PowerPoints for week 10 and 11 to benefit you and to help you in dealing with this week's module. And then you're going to complete the activity rights to suspect, which we're going to talk about in a little bit during this lecture before we adjourn. And then your discussion assignment, taking the 5th and write to an attorney. I've just looked at a few of those, and I posted a comment myself because these are areas that I'm very much interested in. And so your initial post to both of these are due tomorrow night, the 29th, by 11:59 p.m. Central Standard Time. And your reply posts are due Saturday. I believe at that time we're in November. I believe that is the 2nd. I think I'm right. Friday is the 1st. Yep, November the 2nd by 11:59 p.m. Central Standard Time. And once again, as I stated previously, it's all right to respond to more than one post. It makes the discussion forum more interesting, and it gives you a chance to interact with your classmates as well. Finally, we're going to deal with the 2 written assignments, voluntariness of a confession, and your 4th Amendment project, which is the interview. Okay? So you want to make sure you have information concerning that. Now, I will tell you this, and I'll tell you this in a minute when I get to the course project, and I'll explain why I say what I'm going to say. And then you know what my motto is all about. So now let's take a quick look, and you can see, once again, where we are regarding the. You should be very familiar with it. I go to it every week. And you will see, here's where we are, the 28th. And it reiterates what I told you. If you click on it, there it is, right there. And then the live lecture here. Then your initial post, and then your reply post, and then your written assignment, and your project assignment. And then also reminding you that's your key word or phrase. And then on the 4th, we will be doing the final lecture for this course. And you can see, if you click over to November's calendar, you will see that the final lecture will be the 4th, and that all assignments need to be in by the 10th. And so I won't go over that. I'll talk about that next. But the 10th is the last day that all assignments will be due from weeks 4, 5, and 6. Okay? If you submit an assignment on the 10th, on the 11th, I'm sorry, if it's because the course actually ends on that date. It is, here's the reminder. It's right there. Open it up. It tells you that it ends at 11:59 p.m. Central Standard. So you have no reason not to know that particular issue. All right, so now let me close this part down. And let's go right to module. And let's go over the assignments in detail. So your Fourth Amendment, a project, the part for an interview. So what you're going to do is you're going to interview either a prosecutor, a public defender, a private lawyer, a judge, or a police officer. Listen to me good. Not probation officer, but it gives you prosecutor, public defender, private lawyer, or judge to find out what they think about the area of the Fourth Amendment and that what you've chosen. The interview, it says, should be about 30 minutes or longer. That's how long your interview should be, and you should gather enough information previous to that throughout your paper as one of your main and secondary sources. All right? So now, that means that you're going to provide citations in the body concerning who you interviewed. You're going to provide references at the end about any sources that you use as your secondary sources, such as maybe articles, books, or anything else you find. So you're going to write a one-page paper. So it could go longer, outlining what you discovered in this interview. And then, now, when I say outline it, I don't mean necessarily write me an outline. I want it in narrative form, paragraphs. So when I say outlining it, that's what I mean. Don't say, oh, the assignment says do an outline. I didn't say that. I already dismissed that. So if you're going to do an outline, you're going to not understand, and you're not going to pay attention to what I said during the lecture. So you're going to outline what you covered in the interview, what your subject is. That is the subject that you chose week 2. And if you can, include a resume or CV from the person you interviewed. Okay? Now, try to get it. If you don't have it, don't worry about that. Sometimes people have a little brief statement that they'll give you. They may not give you a resume. But the reason why we want that is because we want to make sure that you're not just giving us information, and we sometimes will follow up to make sure that you actually interview it. Don't tell me in the paper I interviewed my uncle and cousin or my best friend. I don't care about the relationship. I just want to know if they fit the criteria of a prosecutor, a public defender, a private lawyer, or a judge, or a police officer. That's what I want to know. And express where they work, you know, department and all that kind of stuff, agency and so forth. All right? So it's at least one page, cover page, citations and references, written, of course, using Word document, and double-spaced, not single-spaced. Did you hear me? I'm going to say it now, double space. If you do single space, I'm going to take points away. All right. And again, it is due on the 3rd. I've shown you the rubric, so I'm not going to go back to that, so you know what's required from the rubric. And then your written assignment, voluntariness of a confession. So you have learned from your resources that a confession needs to be voluntary in order for it to be placed in evidence. You'll discuss that. You'll discover that from your reading and from the PowerPoints. So write a 1 to 2 page paper that includes the following points. Once again, we don't do it in outline form. We don't do it by these bullet points, but these are the points that should be included in your paper. You're going to explain what makes a voluntary a confession involuntary. I already said that. And provide as many reasons as you're able to discover through your research. You know, support your statements with citations in the body and references at the end. Then you're going to find and summarize a case where a confession was held to be involuntary or involuntarily given. and explain the court's ruling. Again, I had said that I recommend briefing it. I'm not really going to require it. But when you do cite a case, use the proper case law citations. I've already given you examples of that in your previous assignments. And make sure your paper is proofread for grammar and punctuation. Cover page, reference page. You should also make sure that it is double spaced as well and submitted in a Word. And then we already, dealing with taking the Fifth Amendment. There's your discussion assignments and the right to an attorney, and then your live lecture. And those are the assignments. So everyone should be clear on the written assignment of the course project as well as the actual written assignment. I've clarified it as best I could. So now let's get into what this is all about. And I am going to discuss the Miranda warnings, and I'm going to give you, we're going to discuss some issues and details right about now. So the Fourth Amendment interview, that's the written assignment. The written assignment, voluntariness of a confession. Your two discussion posts, taking the Fifth and right to an attorney, and then your live classroom. So let's start by talking about, we're going to talk about Miranda, we're going to talk about self-incrimination, and we're going to conclude with the right to an attorney or right to counsel. Let me say at the outset that the rights of the suspect have been pretty much shaped by, of course, applying the appropriate amendment to the Constitution, such as in this one and the next one, the Fifth Amendment, that has been applied to the states by way of the 14th Amendment due process clause and the right against self-incrimination, that you don't have to testify against yourself and those kind of things. So the infamous case, the landmark case, Miranda versus Arizona, I'm going to give you some inside information that you won't get from any other professor, because I know a lot about this case, a whole lot. The case was decided before I went to law school. Actually, it was decided before I graduated from high school. But I learned something in my first year of law school that was very important about this case, and I'm going to share that with you in a little bit. But first, I'm going to lay out the foundation. Miranda versus Arizona, 384 U.S. 436, case that came down from the United States Supreme Court, a landmark case. It actually, as stated here, it determined the way that suspects in custody were treated, and that it cleared up some confusion about how interrogations ought to be operated. Now, the court held that in order, as it says, for defendant statements to be to come to a trial, in other words, if a statement a defendant makes to the police, the state must prove that they have satisfied what we call the Miranda warnings. And many of you know them, and all my law enforcement people, I always remind you that you have to make sure that you do all of them. And so I'm going to talk about what they are. First of all, they each mean what they say. So you have the right to remain silent. In other words, when you are taken into custody by the police, you don't have to say anything. I mean, given your name and birth date and stuff like that, that's not what we're talking about. But you don't have to elaborate or answer their questions beyond that because of the Miranda decision. Now, there is a caveat to that. If you decide to violate, number one, listen to me, in a voluntary method. Remember, now, and we're going to talk about involuntary and what is involuntary. But if you're in a voluntary method under circumstances that makes it clear that the statement that you make is voluntarily given, it warns you in number 2 that anything, and trust me, good people, as a defense attorney, when I was a police officer, I can tell you it means what it says. It says anything you say can and will be used against you in a court of law. So in other words, oh, I didn't know that I should remain silent. Not going to fly. As long as it's clear that you were made aware that you had the right to remain silent. And you also had the caveat and warning that anything you say can and will be used against you in a court of law. Then it tells you further that you have the right to an attorney, which is a Sixth Amendment right as well. We're gonna talk about that at the end. So you don't have to. You can ask for an attorney anytime. You can say, I don't want to talk anymore. I want my attorney. Once you say that, all questioning has to cease. And it is quite clear from the case law that if you do say something after you have made it clear to them that you want an attorney, and they come back later and say, have you changed your mind? That is a violation of Miranda. You cannot do that, law enforcement people. It is as soon as that, when they say, I have an attorney, I want to have my attorney present, or I want to talk to my attorney, not my mother, not my sister, not my brother, unless my mother, brother, or sister is your attorney, then you have to elaborate that. You know, say, oh yeah, my father, my mother, my brother, they're my attorney, but they better be an attorney, not just somebody who has practiced law, they have to be a practicing attorney, so to speak. And then it warns you finally in the 4th point, if you can't afford an attorney, then one will be appointed for you, because it was made clear, and this came out of Gideon versus Wainwright, a famous case. I kind of commented on this in your discussion post, that you didn't have to be stuck with the ability not to afford an attorney. And you should know and be aware that most of the time in that case, the court would appoint a public defender, but if there was a conflict, they might appoint a private attorney. When I was never a public defender, but I was what they call a court-appointed attorney in some cases where there was conflicts with the public defender's office. In other words, it may be a multiple defendant case, and I would represent one of those defendants. So these are the 4 points. Very, very, very clear. In my training and teaching students, and most students now have what they call a Miranda card. And when the rights are given, they generally are read from that card, contain each of these 4. Now, there can be warnings given without that, but we as attorneys, particularly if we're prosecutors, we would recommend, and our commanders and the department policies for law enforcement agents generally require that you use that card, because if you miss any of them and leave it out, then it's not going to work. And you will be probably called upon, as I did many times as defense attorney on the officer testifying in court, to ask them if they gave the rights, and then they'd say, and I'd say, could you give me the rights? And a smart law enforcement person will say, I have a prepaid card, pre-printed card that I used, and then may I use that? Then I'd let them use it. But what I'm hoping as a defense attorney is that they will not want to try to, sometimes they can get very arrogant. And this is, oh yeah, I know these, and start to rattle them off. And then they mess up one. And as soon as they mess up one in the record, boom, they've stated that. And then what the defense attorney, what the prosecutor would then come back and try to do is say, oh, instead of saying this, didn't you mean to say they're in deep water? Then it's like being in quicksand. Then it's not going to fly. So they'll try to fix it up on redirect. But it's not going to happen. It's not going to happen because a good defense attorney, as I was very good, my jury findings were in the high 90 percentile. So I was very, very thorough and I knew what I was doing. And I wasn't tricky, but I was forthright. Some people said I was tricky till they became my clients. Even police officers, I represented some of them that I actually had caught on the stand, not giving correct information, and afterwards they would ask for my card, and not to come after me, but that if they got in trouble, they would come, and I represented some. So anyway, the court also determined, in addition to these rights, these 4 that I gave, that the person must, and I wish that must was capitalized here in capital M, capital U, capital S, capital T, understand the rights. In other words, it must be in language written that they understand. So if you have a Spanish-speaking suspect, even if they speak English, you want to make sure that they understand those rights. So if the suspect only speaks Spanish, they should be given the warnings in Spanish or Polish or whatever their native language is that they communicate and understand. And then that they voluntarily waive those rights. Now, let me explain to you, voluntary means in all circumstances taken into consideration that the individual did so without coercion, without trickery, without, coercion. And coercion can be physical as well as emotional, such as a person being questioned so many hours over and over about the same thing. And then they finally just break and bam, they give it to you. Then there's a question about the voluntariness of that statement that is given. Of course, we already know if a person is physically tortured into confessions. And we have a police officer, former chief, John Burge, J-O-N-B-U-R-G-E, you can Google it. And I actually had a chance to have a few clients that were subjected to this. They were at a department, at a station in the Chicago Police Department, interrogated and beaten. They had electronic prods they would put to the genitals of those individuals. They would do things that violate what we call the Geneva Convention in military. And this was happening in Chicago, and it's happened in other places. And so now, with video cams, we were able to see that. But this was before they had all of that. So anyway, so it has to be given in the language, and they have to voluntarily. The key phrase is voluntarily. And your assignment for this week is to find out some instances where the court has ruled voluntariness. All right. So don't use that as the case that you use for this. That's your landmark case. I know some people are going to do that, but don't. I want you to find there's some cases that have to do with Miranda that came after Miranda versus Arizona. And so these bullet points I want to comment about. Miranda versus Arizona requires voluntariness. Now, here's some examples. Voluntary intoxication is not, you see how they got that in all caps, a defense to voluntariness. In other words, if you get drunk prior to being arrested, you can't later say, oh, I was intoxicated and I did not voluntarily waive my rights. But if you were drugged unknowingly, which is what we call involuntary intoxication, then you can possibly contest the voluntariness of the waiver. So that's a key factor, okay? The bottom line is that you didn't contribute to your involuntariness. The next one is the officers can lie, listen to this, or tell stories to the suspect to get them to talk. For example, and I just said a few minutes ago, no trickery, but listen, let me explain to you what I'm talking about there. For example, an officer can tell the suspect that if he's honest with the officer and tells the officer everything that happened, he'll get to leave custody, even if in fact that's not true. Now that's something that also is being challenged in cases after Miranda, but so far it still stands. So somebody say, well, that's trickery. I said, well, no, here's the point. It goes back to the point. You need to learn point number one and stick with point number one, no matter what they tell you. Number one, that's to remain silent. The officers can't trick you. They can't give you any stories that you respond to and they about a deal or so forth and so on. Nah, it's commonly done. Okay, they'll even tell you that your partner John in the other room has said that you did it. That's proper. Your answer should be, if they tell you that, is not to say anything. Don't try to respond back to it. It means what it says. It says what I mean. Right to remain silent. Okay, that should be pretty clear now. I have had so many clients that I tell them that. They said, well, they told me a lie. I says, I tell you, didn't you learn to remain silent? Now, if they beat it out of you, that's a different, we get to the coercion thing. Remember, we already talked about that. But just trying to trick you, you know, what it is that you thought you had something that could help you. In fact, it came back to haunt you, or as we might say, bite you in the butt, because you didn't do what point number one says, remain silent. Then the third point is the rights can be invoked at any time during the interview. Now, and the officer must stop the interrogation if you verbally say any of these things. I don't want to talk to you anymore, or you don't have to say I want an attorney. You can say I just don't want to talk to you anymore. And then if you say you want your attorney, then it elaborates on it. But the bottom line is that the officer must be made clear. All right. A suspect must actually verbally say it. See, a suspect silent is not enough. You have to say, I don't want to talk to you. Not just don't say nothing, because they don't know what that means. And the case in Burgess made that quite clear in 2010. So you got to let them know. Shrugging your head, your shoulders, and that doesn't do it. And you don't want to do that anyway because you're giving a response, all right, which can be something that can come back and haunt you. Now, the final part I want to say to you, and this is very important for you to understand, a suspect must be in custody. That's the key status for Miranda to be applicable. What it means to be in custody is very simply this. If you are free to go and you're not being detained, even for a short period of time, if you say, okay, am I free to go? And they say no, then you are deemed to be in custody. And any questions or information that is elicited from you the officer is required under the law to give you these Miranda warnings. They don't have to say you're under arrest, as some people think. Arrest is when you're detained and not free to go. And then it says, and you're subject to interrogation to receive it. So then you'll be in a position where they can ask you questions. And there's, as it says, a bunch of cases that deal with that and what is exactly in custody. But it's going to boil down to what I just said a few minutes ago. If you are not free to go, then you are in custody. Now, let me give you the extra stuff that I want to tell you about Miranda versus Arizona. I had the privilege of being in law school at Northwestern University School of Law with a professor by the name of Fred, F-R-E-D, Inbau, I-N-B-A-U. We used to call him Freddie the Cop. Professor Inbau is the co-author of the techniques based on a book, Interrogations and Confessions. He authored that book with a guy by the name of John Reed, R-E-I-D. And that book was used by the law enforcement agencies for many years. And that's the technique that was used in the Miranda case. And that is the technique that the Supreme Court goes over and explains why it violates the Fifth Amendment of the Constitution and the Sixth Amendment, but specifically the Fifth Amendment. And thus arose the Miranda warnings. My professor told us in class, this was in August of 1975, in our big call, that he felt personally maligned by the United States Supreme Court because of their position, and he hated, I didn't say dislike, he hated Miranda. He wanted, and he spent time, every time a case came up before the United States Supreme Court pertaining to Miranda, he would submit what we call a friend of the court brief, or we call an amicus brief, on behalf of, I think it was the National Association of Prosecutors, whatever that national organization that he was a part of. And the court would see those briefs. His goal was to get the court to overturn Miranda versus Arizona. And he wanted that, and that's the way he took it. It was very, very, very interesting piece for me to learn because I read the book. I actually had the book in my library for many, many, many years, and I think it may be still in print, but it's called Interrogations and Confessions by Inbau, I-N-B-A-U, and Reed, R-E-I-D. And it outlines the basis of what the Supreme Court says, this is not good, and it violates the Constitution, and thus the birth of the Miranda warnings came out. That is something that you won't hear from any other professor because I got this firsthand, or as they say, straight from the mouth of the party. So that's what I want to say about Miranda versus Arizona. So now let's talk about the next topic in terms of defendant rights, the good old Fifth Amendment, or as we often say, we plead the Fifth. The Fifth Amendment is written out here, and I'm not going to read it over to you because it's right here in front of you. But what it does is that what you're going to say during a legal proceeding, that if a question is asked of you, and by your providing an answer, because you're going to be under oath to that question, you will incriminate yourself. So the Fifth Amendment says, and usually they'll have a little card that the lawyer will give them, I respectfully plead the Fifth Amendment. And they won't answer those questions. And that's because the Fifth Amendment says what it says up here, and you read it. So taking the Fifth, doing a legal proceeding, if they believe that that statement would incriminate them. You don't have to incriminate yourself. Now, listen, let me say this out front. The average person says, you know what? That means then the jury or the trier of fact knows that you're hiding something. Well, that's true. But so what? Because of the fact that your lawyers and the judge with the jury instruction is going to direct the jury to understand that that is a constitutional right that you have, and that they should not take that into consideration in terms of reaching a verdict or finding you guilty beyond a reasonable doubt. Now, because we're dealing with people, it's not an exact thing, but that's the philosophy behind it, so that you understand it. But it is better for us to withhold that information than to let that information come out, because that information comes out is equivalent to taking out a gun and shooting yourself in the head in front of the trier of fact. That's kind of like a good example there of what you're doing. At least here you're having still a chance that the Constitution has given you to say you don't have to help the prosecutor with their case. That's what it boils down to. And so this is done outside the ears of the jury and prior to testimony given. So when I say that, that is not something that the trier of fact would even hear. But I have seen situations where the Fifth Amendment does come into effect in a trial with the trier of fact. That's why I mentioned that part. But procedurally, what the lawyers do is they make it known that in a hearing with the trier of fact. Now, you're kind of in a pickle when it's a bench trial, because you're going to do it before the judge. It comes about in that situation outside the jury and prior to the testimony. So what that does is that if it's that particular information cannot, listen to me, cannot be asked of you during the trial itself. If it is, then it's going to be a mistrial, because then the person who asked the question, which would generally be the prosecution, will have said, I don't care about your Fifth Amendment right to remain silent. I want the information. And then they have violated your rights in front of the trier of fact. Now, let's go to the next part. It says, if it's in the middle of a legal proceeding, the judge will generally recess the jury. Generally, did you hear me? Sometimes it's not. I'm telling you, most of the time it is, and inquire further. If the judge agrees that the person's statement would incriminate them, then the other side may request a mistrial, which is what I just said a few minutes ago, because, oh, okay, some of it has come out already, or that all the previous testimony is stricken from the record. I hate that. I can't stand that. Strike it from the record. I always say that whenever something is said in court, what they're saying is that it doesn't go into, it's in the record, but it's not in the record. Here's what I'm trying to say. My mentor, attorney R. Eugene Pincham, a great jurist, and became a criminal court judge for many years, and then an appellate court judge. He used to tell us young lawyers, he says, I hate that phrase because it means nothing in application unless you perform a lobotomy on the jury. And you get my point there. So you can't, once it's, as they say, you know how, psychologically that words, words can really, really affect an individual. Where words given can cause an individual to rely on those words and so forth. And so you begin to get my point from that particular situation. So the Fifth Amendment is very critical. You also will run across the Fifth Amendment. We're not dealing with that right now, but I just give you an aside, is that when you have congressional hearings, or if you have other hearings, the key thing is that you're under oath. You're under oath, and you don't have to be compelled. And it says here in the Fifth Amendment, the part that I'm going to read, it says that nor shall be compelled in any criminal case to be a witness against themselves. That's the part that applies to the Fifth Amendment, what we call the right not to incriminate yourself or self-incriminate. All right, so I've given you a lot of clarity on that, a lot of good information. So now let's conclude by talking about the final part of this piece, and that is the right to counsel. Now, as I said earlier, under the Fifth Amendment, a person has a right to a counsel based on Miranda. However, though, the Sixth Amendment, under the Sixth Amendment, after a suspect has been formally charged with a crime, the prosecutor cannot speak to the defendant without their lawyer present, in or out of custody, okay? In or out of custody. So the Miranda part goes into in custody. But if a person has an attorney, then in that case, out of custody, then you concentrate on that attorney. You don't call that defendant. So if you're conducting your investigation as a prosecutor and that person is out on bond, you can't go to that person and ask them about the case. You can't do that. You really can't, because that would violate the Sixth Amendment. And so after they've been formally charged, now, that's after they've been formally charged, all right, but not before. An investigation continues after the formal charge. And it gives some examples here. For example, if Officer H brings in Sam to the station to interrogate him because Sam is the suspect in a recent retail theft case, Officer H must advise Sam of his Miranda warnings. And, you know, because the purpose, he's going to be in custody and interrogated, okay? Now, if Sam says, I want my attorney, then the officer has to wait until the attorney is present before continuing the interrogation. I kind of said that earlier, but this kind of clarifies it in terms of the individual protecting them. I thought about it, you know, and I'm just showing you a hypothetical. I thought about it, Officer H. I could do this without my attorney. Officer H better not try to question that person, because they're going to be in trouble. They're going to violate Miranda, and they're going to possibly violate the constitutional Sixth Amendment right. So if Sam is held in jail and later formally charged for the theft, the officer can't question Sam again without the lawyer. Now remember, this is before, then this after as well. So you kind of get the point. What's the general rule? You can't question that person. You need to deal with their attorney. That's the answer to the question. Okay. So now let's say Sam is released and no formal charges were filed against Sam at that time. All right. So he just say, okay, Sam, you're free to go. Get him to the police station, get him again. At a later date, then Officer H would more than likely have to give the warnings again. And Sam would have the right to invoke his right to counsel again. The key is how he's brought in, what he's brought in for. If Sam did not invoke this time, the second time, a court would probably find that Sam's statements made at the second interrogation would be allowed in the evidence, because time will have passed between the original and then the second. Now, here's the key, the issue. If you notice that it says too much time, the gap has to be an apparent one. You know, like maybe there are cases that argue that even 1 hour later, or 2 hours later, or 1 day later, or 1 month later, further you get away from the original time, then the the more likely on the second time you're going to have to do it. What's the best practice? Best practice is to give the Miranda warnings in any case, either time. That's what most departments teach law enforcement to do. And if I was a prosecutor, which I was, I would encourage police to do that exactly. If a suspect is in custody on one charge, while that charge is pending, the police are investigating him on another crime, and they bring him into an interrogation room to ask him about the new crimes, the suspect must be given new Miranda warnings. So you begin to understand the right to counsel is something that's protected quite a bit. And the suspect must also invoke their right to counsel to have a lawyer present. So you got to always keep saying, I want my lawyer, I want my lawyer. And suspects say it all the time. That's good. But when they say it, they don't have to keep repeating it. They say it once, and it ought to be honored. However, the police may not question him regarding the case that is already pending for which he is formally charged without the lawyer present. So you see my point that I just made a few minutes ago. The final example is that if Sam is charged with retail theft, and then he's later brought into custodial interrogation regarding a domestic violence crime, which is two separate crimes, the officer must advise him of his Miranda warnings, and Sam has to invoke his right to counsel. But the officer cannot ask Sam about the retail theft, since the Sixth Amendment protects Sam, and he can't and cannot be questioned without his lawyer present on that matter. So you see what I'm saying here. When you look at cases like Gideon versus Wainwright, Escobedo versus Illinois, two leading cases, you will, and then there was a famous book that was called Gideon's Trumpet, that it also was made into a movie. I shared it with some of my students in the past. It elaborates on the the right to counsel in Gideon versus Wainwright. And Gideon v. Wainwright is a case that I'm looking up something in a minute, but I think I'm right about what I'm about to say. Give me a second. Yeah, here we go. Okay, we know that Miranda came out in '66, and Gideon versus Wainwright was before that. I thought so. It was 3 years before that, and it established the 14th Amendment state to provide attorneys, which kind of flowed into one of the rights, right number 3 and 4, so which is really a part of applying Gideon versus Wainwright, and then Escobedo versus Illinois, which came after that as well. So yeah, so the '63 Gideon versus Wainwright and Escobedo versus Illinois, which came out in '64. So they kind of like came about, and so a year after Gideon versus Wainwright. So that's two cases that you cannot discuss the right to counsel without mentioning those two cases, at least the first one, Gideon versus Wainwright, and Escobedo. Gideon versus Wainwright, the citation for Gideon versus Wainwright is, give me 1 second, it is 372 U.S. 335. You'll see it in my discussion post that I posted for you as well. Okay, and then Escobedo is, let me see, give me 1 second while I pull it up for you. 378 U.S. 478 and it was 1964. So anyway, that's it for this session. Do you have any questions? If so, type it in the chat box. Or if you have no questions, type in the chat box. Any questions? Okay. So I think that it is, you learned quite a bit here today. My expertise as having been a criminal defense lawyer and the experiences. So like I said, it's an exciting, it's fun for us. It's one of our major tools. If we're not using the Fourth Amendment, search and seizure, then we're probably using the Fifth and the Sixth Amendment. Those are what we call our foundational defense attorney constitutional amendments, protecting the rights of individuals. So I want to give you a key phrase. And the key phrase is interrogation. That's it. Just give me that, and you get your points. So with that, I'm going to say good night. It's about 9:28, and I'm within my hour, as I said. And you're welcome. And I think that when you come to the live lectures, you're able to hear firsthand, and then I give you the opportunity to ask questions. But I think I do break it down pretty well. I can tell you this, if you were in law school and this very same lecture took place, first of all, number one, each of those areas that I covered, the Miranda, the Sixth Amendment, and then the self-incrimination, each of those might be broken down into 4 to 5 lectures. I'm not kidding. Miranda, we might spend 3 lectures on going over those rights and dealing with cases. And I had to go through all of that. So that's why when you come out of law school, you kind of know this course that you're taking, I'm not trying to turn you into lawyers. I mean, if you decide to become one, then, you know, you're going to elaborate more on it. But the bottom line is that you'll have a lot of good information that would help you. And knowledge is something that you should not be allergic to. I always tell young people, old people, and I'm a source of knowledge based on my experience, and I enjoy, as you know already, those who've had me in more than one class, and many of you in this class know me from Introduction to Corrections, Drugs and Crime, Introduction to Criminal Law, and Contemporary Issues in Criminal Justice. And, you know, some know me from other classes I've taught, evidence and so forth. The bottom line is that I love to give my students more than what you get from your reading and your material. And I like interjecting my experiences because it clarifies what's in the book. Otherwise, it's all boring. So I'm going to say good night to you. Have a great week, and I'll see you next week at the same time. Reach me if you need me, and I'm not going to go elaborate on that at all. Say good night.